Well, thank you. We've now heard the evidence and I've read the bundle. I'd like to hear from you both now with your closing submissions. I don't think I'll have time this afternoon to deliver my judgment, so I will reserve that and come back in writing. But I'd like to hear your oral submissions on behalf of the parties, please. So, Ms. Partridge, would you like to begin on behalf of your client, Vicky?
If it pleases the court, my name is Skye Partridge and I'll be representing the appellant, Mrs. Victoria Humber, in this case. To my left is my learned friend, Mr. Ralston, and he is representing the respondent, Mr. Ian Humber, in this case. If it pleases the court, I would like to begin with a brief depiction of the facts of this case. Ian and Vicky Humber are deciding to separate as of the 1st of December 2014 after 12 years of marriage. They remain cohabitants of their family house, Drake House, and they have 3 children, Arthur, who is 11, Beatrix, who is 9, and Eddie, who is 6. Both parties wish to resolve this issue amongst their children and prioritise the children's welfare in this case. They want to remain both parties who see the children regularly, they want to come to an agreement that works for all the parties involved in this case. Vicky wishes the children to live with her full time and only have some brief visitation with their father, which will be quality time with him as he does work a 40-hour week. However, Ian wants them to live 50-50 between the houses, which we believe will be very unsettling for the children and would affect their welfare even further. The care of the children have also been given to the grandmother in the past when the mother had to work part-time before the birth of the youngest child. If the mother has to go back to work, the grandmother is willing to step back in and give a further support system. However, Mr. Humber does work, as I said, a 40-hour week, and so this is the issue of the quality time, and we don't want the children to spend bad time with their father. We want this to be a very cohabitant relationship between all parties. If it pleases the court, I will begin with my first submission of the Child Welfare Act in the Children Act 1989. Provisions A to G set out the court process in terms of dealing with the child welfare and putting the child welfare first. Obviously, the children's care and what they need needs to be put first in this case, and we believe that the mother will be able to give them that proper care over the father, and that is what we are asking the court to order on. The welfare checklist will allow the court to order on this and make the best decision based on the child's welfare. I shall be focusing mainly upon B, C and F of section 1.3 of this Act, and it has been established from part A, if you refer to the bundle, it is on the pink tab of the skeleton argument. Point B, sets out his physical, emotional and educational needs. Arthur has not been completing his homework and Eddie has not been speaking to anyone. And so the emotional needs and the educational needs are very directly linked to this case. If there's already some form of disruption in the family and to the children from this unsettlement, that just shows that there needs to be something put in place for these children to settle down again and not be worried. We don't want this to go any further. We don't want his education to be at more of a jeopardy than it already is, and so we believe him remaining with the mother, remaining in the care that he's used to, will avoid this future risk of an infliction on his educational needs and also emotional needs. The emotional needs specifically aren't known fully in terms of the children, as they haven't been very open about their feelings. However, Eddie hasn't been speaking to anyone, and as a young child that's very unsettling, and we believe it is because that they're all concerned of where they're going to be living and what their future is going to look like, and we believe that if they do stay in the house that they've been raised in, they have the support system from their grandmother, from their mother, they still have visitation with their father, this is going to be the best situation for them to remain as normal as possible, and there won't be any future risks in terms of their welfare. I will also direct you to section C, and that reads, the likely effect on him of any change in his circumstances. As I said, although the wishes of the children aren't known, we believe that if they are moved and their circumstance is changed so much, this is going to cause future issues. Already there has been an unsettlement and a worry amongst all the children, and by moving between houses 50-50, which is uncommon for most children anyway, that is going to cause even more unsettlement. It's going to worry them even further and have those detrimental effects on both their welfare, their education and emotional needs. Also, the father now has a new girlfriend, and we believe that that will push off onto an even more unsettlement of the family if they're being exposed to new people. At the moment, the parents are cohabitants, and so they haven't been exposed to this 50-50 lifestyle. They have been with their parents. So for them to worry, and they haven't even seen the parents separate as of yet, to bring in new parties would be worse for the children and really affecting their welfare, and we don't believe that the court should allow that to happen, and they should order in the favour of who's going to give them best care as of this provision.
Sorry, could I just ask, have the children met the new partner?
They have not, no, and we believe, the mother particularly believes that it would create even more of an unbalance, because it's bringing in a new person. They're already upset that their parents are divorcing, and so to have a new partner brought into the mix, I think that's going to cause a lot of confusion even further, and we don't want there to be any more than there already is. We want to handle this issue first and have the children prioritised before looking into the future and thinking about dynamics in terms of new partners and things like that. I will now bring you to the final provision which I will focus on, which is section 1(3)(f), and it reads, how capable each of his parents and any other person in relation to whom the court considers the question to be relevant is of meeting his needs. This then relates and concludes that the parent who can give the best care should be chosen to have that care and have that sustainability with the child. The children have lived in Drake House their whole life. This is something that they're used to. This is a normality for them, and through such a difficult situation that they're not used to have something that they are used to would be very beneficial for the children. And I think it would make this process a lot smoother. It will make, the situation easier to handle in some circumstances, and so then we can kind of think about kind of bringing in, as you mentioned earlier, kind of the newer partners and things like that, and deal with that at a later date. But for right now, the child's priority and their welfare is what we're focusing on. They have had 12 years of marriage, the parents have, and so the children have already built up a very strong relationship with the father. We don't believe that they would need any extra time with their father than normal, because they have this bond. They don't need to build up an extra bond with him. They know him, they trust him, they have a good time in their father's care. However, he works 40 hours a week, and to most parents that may seem like a normal week, but I'm sure most parents can also agree that at the end of a long day, they come home, they're tired, they might not be able to spend optimum time with their child, they might not be able to give them the attention that they need. Whereas my client, the mother, does not work. She has the means to look after the children. She could be available anytime they need, and so that is something that the court should consider in terms of she will be able to give the optimum care. She will be there anytime they need. For example, if the mother did have to go back to work for whatever reason, they would be able to go into the care of the grandmother, which they have already had in the past, which again is a normality bringing into the future. They will be able to keep a close relationship with the grandmother. And if I refer you to the green tab in the bundle, it refers to the case of Re-W, and in this case it was giving the grandmother some time with the children and giving her custody of the children. However, in applying it to this case, as the court found in Re-W, it established that a constant relationship with outside parties and extended family is actually very helpful to the children. It's very good for their welfare, and having that established family and bond with people. And so bringing it to this situation, I think it's very important that they remain having time with their grandmother and on top of their family life and on top of their mother and the father. And so that will just add, again, normality. It will help settle them. It won't bring in any new factors, and they can maybe stop a bit more worry. They can be eased into this process, because as young children, this is quite a shock to them. They weren't expecting this to happen. And so although the parents have been trying to work it out, there has been no definitive separation. So as far as the children are aware, they haven't seen that break of the family. And so I think that will be a big shock to them. And so bringing in as many things as they're used to, I think, will ease that process and keep the child's welfare at the optimum place it should be. And concluding, the case of JNC, which is on the green tab on the final page of the bundle, this case concludes that the court should use the checklist A to G and the provisions that I've explained in my submission to see who has the optimum welfare for the child, see who can care for the child the most. The mother has every day to look after them. She can be whenever they need. She has the means to look after them. She has the house that they've grown up in, and they could remain going to school on their normal basis. They could keep as much of their life now as they can, and then obviously have visitation with their father. They will still be allowed to see their father, of course, and obviously the mother really wants to work towards having that balance, having the father involved, because the children want to see their father, and she wouldn't exclude him from that. However, I think it should be based on both parties. I think the father should have quality time with his children, and if he can't do that within the working week without sacrificing his work and then his means to live a standard of life of his own, I don't think that should be the case. However, we are willing to work with the father and create an established schedule that works for all parties involved and try and create this normality. In light of this, we hope the court will rule in the mother's favour of this custody, and if you have any further questions, I will take them now.
Thank you very much, Ms. Partridge.
Thank you.
Mr. Alston, could I call upon you? I don't think I need to trouble you to explain the provisions of the Children Act. I'm very much aware of those, but I'd like to hear what the father has to say about any changes in what Ms. Partridge has described to me as really what is the status quo.
Of course, thank you, Your Honour. I'm grateful for the introduction of the facts, and from myself, from my learned friend here. I will make my own substantive propositions on behalf of the respondent, Mr. Humber, in this matter, of which there are 3, and I intend to take you through those chronologically as per the bundle provided to you. Now, you mentioned you would like to hear about the status quo. Perhaps I may address some of the points raised by my learned friend within the welfare checklist before doing so.
Yes.
If I begin my submission by considering the welfare of the child, and specifically Ms. Partridge has referred to section 1.3b of the welfare checklist, the physical, emotional and educational needs of the child here. We have no concerns about the child's physical or emotional needs, and merely we are only concerned with the educational one at this stage. And my learned friend has submitted and drawn their attention to the fact that Eddie is showing signs of withdrawal, Eddie being the youngest child here, and Arthur, as the eldest, not paying as much attention to his homework as perhaps he should. And we would submit that this disruption is owing to the deliberations over the living arrangements between the parents and the continued state of affairs that occurs, whereby the children are unable to know with certainty as to how often they will see their father. We would suggest that this has only become an issue having since filed for the divorce proceedings. Prior to that state, there was no such question of educational development, and thus, by allowing a shared residence order in this case, would return that state to the children, and they would be thus allowed to proceed with their educational development unhinged by the fact of the divorce between their parents. Now, next I'd like to address section 1.3c of the Children Act of 1989, and this is the likely effect of any change that it will have on the children. My learned friend has submitted that a more settled living arrangement is in the current situation. They currently reside in Drake House, the family home, and therefore shouldn't be removed from that premises as it will be detrimental to their welfare. Now, we would say in response to this, Mr. Humber is not seeking a change of residence. He is merely seeking a 50-50 division of allocation of time between his children and between himself and the mother. Ms. Partridge has asserted that the children spend time with my client daily, and indeed they have been having done so given the length of their marriage being 12 years. These children are aged between 6 and 11. They have not known anything different than spending time with their father. However, we would suggest that this, as Ms. Partridge quite rightly stated, this relationship, although seeing him every day, is not a quality time because he is in this feud with his wife and they've issued divorce proceedings, and therefore he doesn't have sufficient time to spend or quality time with his children. Now, the issue of harm under section 1.3e is something I wish to address later in my submissions. You'll find this at paragraph 7 of my skeleton, and so for the time being I'll come back to that. But merely I'd like to address the issue of capability. Now, there's no confirmation, Your Honour, that the appellant will return to paid employment after these proceedings are over. Now, raising 3 children is very expensive, and perhaps I may draw your attention to the financial statement you'll find in the bundle. And the benefits of Mrs. Humber is unrealistic to therefore suggest that she is able to maintain the upbringing of these children without the supplemental help of my client. Now, the appellant has been out of employment for a period of 9 years. We're told she was previously employed on a part-time basis as a teacher prior to the birth of her youngest son, Eddie. Now, whilst it's not impossible, we would submit it's highly unlikely that she is able to return to paid employment immediately. And if the appellant did in fact return to work, Miss Partridge asserts that they would be placed, or the children would be placed in the care of the grandmother. Now, we would submit that this only serves, therefore, to drive a further wedge between the father and the children. Not only is the father deprived of quality time with his children, being the non-resident parent in this case, but he is replaced by a third party owing to the relationship of Mrs. Humber and her mother. We would urge the court, therefore, to consider the capability of the grandmother in question. We do not know the age of the grandmother, but we would question whether her physical health is stable enough to continue to support these children as they progress through their development. We would suggest that it's therefore not in the interest of public policy to deny Mr. Humber contact with his children, to replace them with, or his residence with the grandmother, and then continue to pay for a house in which he no longer resides. Now, my learned friend has submitted that Mr. Humber works a 40-hour week, and this was detrimental to the welfare of the child. But we would suggest that many parents do, in fact, work 40-hour week and do cope on this basis. My client is actually prepared to work flexi hours, and in the weeks where his children do not reside with him, he would work an increased workload and then a reduced one when the children do, in fact, come to spend time with him. So he is there to provide for them and to spend that quality time when he has a residence with them. Now, Ms. Partridge has relied on the case of Re W as a authority for a relationship to be maintained between a grandmother in that specific scenario and the children. Now, we're not suggesting that or disputing that they should not maintain a relationship with the grandmother. We are merely suggesting that it is perhaps in the interest of the children to reside with Mr. Humber as opposed to the grandmother. And on that basis, we suggest that Ms. Partridge has omitted to emphasise the importance of the changes that were made to the Children Act in 1989, as introduced by Section 11 of the Children and Families Act 2014. Now, this introduced an ongoing presumption, which is only rebuttable in the case of harm, that it is in the best interest of a child to maintain a relationship with both parents after separation. And we would submit that, therefore, to find in favour of the appellants would be contrary to that presumption contained within the Act. Now, as well established in the case of Re A, that it is in the child's best interest to maintain the relationship with both parents, and you'll find this in tab number 4 of the bundle provided to you at paragraph 108. And of course, we cannot measure the quality of that relationship in terms of time only, but also the nature of that relationship. And we would submit that Mrs. Humber's approach, or the appellant's approach of spending merely 60 days with Mr. Humber and the children, is not a sufficient time or allocation of time to develop and foster that relationship and have a sufficient quality of relationship to maintain the state of affairs that currently exist, or prior existed prior to the divorce. Now, as for the precise allocation of time, as Your Honour is aware, we are making submissions for a division of 50-50. So 1 week with my client and 1 week with the appellant. And for that authority, you can rely on the case of Re and M of 2014. You'll find at tab 4 of the bundle. Now, His Honour in that case refers to some factors that must be present when seeking to make a 50-50 arrangement order. And these are close geographical proximity and the parents to be on reasonable or good terms. Now, in addressing in the former, Mr. Humber, as we have suggested, is not seeking a change of residence. He is not seeking to uphaul the children from their current place of residence in the Drake House. He is not seeking to change towns. He is merely suggesting that they reside with him in a premises nearby once a week. And so that satisfies the geographical proximity element. And in terms of the reasonable or good terms, in terms of the relationship between the parents, this is evidenced in the facts where Mrs. Humber herself agrees that the relationship was, she describes it, good. And indeed, they enjoyed going out on weekends and a holiday at least once a year. In the case of Re-M, the judge ruled that had the geographical proximity not been called into question, he would have found in favour of a 50-50 division of time between both parents. But in that case, one had been in Newcastle and one had been in London, and therefore that wasn't possible. And so we assert that therefore the learned friend has not been able to rebut the ongoing presumption now found within the Children Act of 1989 that it is in the best interest of a child to maintain that relationship when considered cumulatively, and deplore the court to find sympathy in the position that Mr. Humber finds himself in. He is not, as I've said, seeking a change of residence, but merely believes that an equal and committed relationship with both parents is in the interests of the child. Now, do you have any questions at this point before I address submissions 2 and 3?
No, simply that the change in the law didn't specify, didn't mandate, did it, that the involvement of both parents meant that there should necessarily be an equal division of time?
No, it did not. Quite the contrary. It does say in the Children Act that there doesn't need to be an equal division of time per se. It is just merely the quality of a relationship. We would suggest that that is best achieved through this division of time that we're suggesting. Mrs. Humber asserts that Mr. Humber should only be able to see his children once a week at Easter, once a week at Christmas, every other weekend, and potentially 2 weeks in the summer if his work permits. And that cumulatively is only 60 days, and we would therefore question as to whether 60 days in a year, having gone from a state of affairs where the children see their father every day for 12 years, and indeed have been brought up by him, could amount to a quality relationship that is necessary to benefit the welfare of the child. Now, if I may turn to my final submission, and this is, again, deriving from the Children Act of 1989. It's on the issue of harm as described in section 13E of the Children Act. And we would suggest that the children, by not being able to establish a good relationship with their father, are at risk of being caused harm. Now, the term harm is deliberately wide-ranging and therefore covers both physical injury and psychological trauma to the children. And indeed, the Adoption and Children Act 2002 has extended that meaning to include the impairment suffered by the hearing or seeing of the ill treatment of another. Now, we would not care to comment on the nature of the dispute between the parents. It's certainly not physical, but we cannot rule out the question that the children have at least been subject to, given the duration of this dispute, some harm, albeit in a psychological manner. And now I refer to the following 4 ways in which the respondent would suggest the children have been caused harm.
Let me interrupt you. There's been no report from the Child and Family Court's Advisory and Support Service, so issues of welfare haven't been raised thus far.
Correct, yes. There are no ascertainable wishes of the child of which the court can rely on. We would merely suggest that it is in the remit of the court to consider the possibility that the children have been subject to harm by witnessing this ongoing acrimony that's been part of their lives since 2014, when the parents issued divorce proceedings. We're told it's quite a volatile relationship between the two, with, again, Mrs. Humber suggesting that the children only have a small and limited window to see the father. We are told in the facts of actually in a turmoil of the children, some wanting to reside with Mr. Humber and some wanting to reside with Mrs. Humber. And so therefore the possibility of, albeit a minor degree of some psychological harm, we would suggest could not be ruled out in this case. And so we consider, in the absence of violence, as we've suggested is not relevant in this matter, the fact that one parent denies sufficient contact with another parent could be construed as a case of, or seen as a form of harm, and for that authority you can rely on the case of Reece in 2007, which you'll find at tab number 6 in the bundle. And so in that case, the court placed great emphasis on considering the emotional needs of the children, and specifically the ties with which they have with the parents and siblings, and the trauma that may therefore flow from the severance of those ties. We've said before that Mr. Humber lives with the children and has done so for the past 12 years, but we are told of Eddie's, the youngest children, not wanting to communicate with siblings or his parents. And we suggest that if Mr. Humber would effectively be ostracised from the relationship, that would cause substantial harm to the children, not only Eddie, the youngest, but also through to Arthur, the oldest, who is refraining from doing homework or not committed to his school as much as he should be. And we therefore submit that an equal division of time between the children, by way of a shared residence order, would be the most appropriate to restore that mental state of health of the children and further their welfare, as is in line with the ongoing presumption introduced by the Children and Families Act 2014. If there are any further questions at this point?
No, thank you, Mr. Alston.
Thank you.
I will deliver a judgment in writing in due course, and I will email it to both of you, and a date will be fixed for me to then give the judgment when your clients can attend. Thank you.